Students, so today we are discussing from Order 5, issue and service of summons. Order 5 of the Code of Civil Procedure. In previous videos we have discussed from Order 1 to Order 4. Now in Order 5 deals with issue and service of summons. Issue of summons. Order 5 Rule 1 says summons. What is summons? Sub-rule 1, when a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim on a day to be therein specified. So, a summons is a notice to the defendant to appear and defend his case on a date specified, provided that no such summons shall be issued when the defendant has appeared at the presentation of the plaint and admitted the plaintiff's claim. So, if the defendant is present at the date of the presentation of the plaint and admitted the entire claim of the plaintiff, no summons shall be issued. Now, provided further that where a summons has been issued, the court may direct the defendant to file a written statement of his defense, if any, on the date of his appearance and cause any entry to be made to that effect in the summons. So, in the summons, there is also a direction, always a direction that such and such date has been fixed to file the written statement. That is the version of the defendant, the story of the defendant, to whom a summons has been issued under sub-rule 1 may appear A, in person, or B, by a pleader duly instructed and able to answer all material questions relating to the suit, or C, by a pleader accompanied by some person able to answer all such questions. So the defendant on receiving a summons has option either to appear personally or appoint a pleader who has been instructed in such a manner that he is made capable of answering all the questions regarding that litigation, or he may or the defendant may engage a pleader accompanied with a person who knows all the material circumstances of the case. Now Rule 3 says every such summons shall be signed by the judge or such officer as he appoints and shall be sealed with the seal of the court. So the summons must be signed by the judge and the seal of the court must be there. Now coming to this is Rule 1, Sub-rule 1, Sub-rule 2 and Sub-rule 3. Now coming to 2 of Order 5. Copy or statement annexed to summons. Every summons shall be accompanied by a copy of the plaint or, if so permitted, by a concise statement. So the notice or the summons must be accompanied with the copy of the plaint or the statement. Now 3 says the court may order defendant or plaintiff to appear in person. Now, the court always has a discretionary power to order the plaintiff or the defendant to appear in person. So, where the court sees reason to require the personal appearance of the defendant, the summons shall order him to appear in person in court on the day therein specified. So, it is as simple as that. If the court thinks that it is necessary for the defendant to appear in person, then it will direct accordingly. Now, Rule 3, Sub-rule 2 says where the court sees reason to require the personal attendance or appearance of the plaintiff on the same day, it shall make an order for such appearance. Okay. So, Rule 3 says a personal appearance of the parties. Now, Rule 1 says about the defendant and Rule 2 says about the Sub-rule 2 says about the plaintiffs. Now, Rule 4, no party to be ordered to appear in person unless resident within certain limits. So these are the specific areas from where your preliminary examinations questions will be set up. That Order 5 Rule 4 says no party shall be ordered to appear in person unless he reside A, within the local limits of the court's ordinary original jurisdiction. Okay. So, if the person is not a resident within the local limits of the court's ordinary original jurisdiction, then he cannot be ordered to appear in person, and B, without such limit, but at a place less than 50 or where there is a railway or a steamer communication or other established public conveyance for 5/6 of the distance between the place where he resides and the place where the court is situated, less than 200-mile distance from the courthouse. So you have to remember that it is less than 200 miles and 5/6 of the total distance from the courthouse to the person's address. Okay, the majority portion is covered by public conveyance. This is the criteria. If in such a scenario, the person, though he may not be a resident within the local limits of the honorable court's original jurisdiction, he can be ordered to appear in person. If there is public communication of the distance, or I mean the 5/6 of the distance between the place where he resides and the place where the court is situated, and which is less than 200-mile distance from the courthouse. Okay. Now, Rule 5 says summons to either to settle issues or for final disposal. Now, what is the summon is all about? Notice is okay. Now what is about the notice? What is the agenda of the notice? Now, the court shall determine at the time of issuing the summons whether it shall be for the settlement of issues only or for the final disposal of the suit, and the summons shall contain a direction accordingly. Okay. Now, provided that in every suit heard by a court of small causes, the summons shall be for the final disposal of the suit. So, in case of any other suit, it can direct for the settlement of issues or for the final disposal of the suit or for filing the written statement, or he's presenting the defendant's version of the story, whatever it may be. But in case of court of summons issued by a court of small causes, or in every suit heard by a court of small causes, the summons shall be for the final disposal of the case. Okay. So, in case of small cases tried by the court of small causes, the summons are generally issued for the final disposal of the suit. Now, then comes the fixing a day for appearance of the defendant. Rule 6 says the day for the appearance of the defendant shall be fixed with reference to the current business of the court, the place of residence of the defendant, and the time necessary for the service of the summons. And the day shall so fixed as to allow the defendant sufficient time to enable him to appear and answer on such day. So, the court will fix a reasonable time or reasonable date so that the defendant gets the opportunity to defend himself in a reasonable manner. Okay. Now, Rule 7 says summons to order defendant to produce documents relied by him. So, the summon to appeal and answer all the summon to appeal and answer shall order the defendant to produce all documents in his possession or power upon which he intends to rely in support of his case. That is, that is in Rule 7, it has been, I think it is a typographical error. That is, the summons to appear, not appeal. It is the summons to appear and answer all shall order the defendant to produce all documents in his possession. Simply, the summons in with the notice of his appearance also calls for all the documents or necessary documents in his defense which he wants to present to be presented or to be brought before the court with him. Okay. Now, 8 says on issue of summons for final disposal, defendant to be directed to produce his witness. Now, where the summon is for final disposal of the suit, it shall also direct the defendant to produce on the day fixed for his appearance all witnesses upon whose evidence he intends to rely in support of his case. So, in cases where the summon is issued for the final disposal of the case, the defendant must be fully ready to defend his case at the date fixed. He must be acquainted with all the documents, accompanied by all the witnesses. He must be fully ready before the court. Okay. Now, coming to the point, these are the contents of the summon and how it will work and when it will be served, upon whom it will be served, who will appear, what is the the time limit. These are the things. But now, coming to service of summons. Now, delivery or transmission of summons for service. Rule 9. Where the defendant resides within the jurisdiction of the court in which the suit is instituted, or has an agent resident within the jurisdiction who is empowered to accept all the service of the summons shall, unless the court otherwise directs, be delivered or sent to the proper officer to be served by him or one of his subordinates. Okay. Now, who will deliver the summons? The proper officer. The summons shall, unless the court otherwise directs, be delivered or sent to the proper officer to be served by him or one of his subordinates. Okay, the proper officer or his subordinates, in accordance with the direction of the superior officer, will serve the summons. Now, subrule 2 says the proper officer may be an officer of the court other than that in which the suit is instituted, and where he is such an officer, the summons may be sent to him by post or in such other manner as the court may direct. So, it may be a case where the summon is issued by an officer who is not an officer of the court where the suit is situated. So in such a case, the summons will be served to the specific officer, and the medium will be by post or in such other manner as the court directs. Now, Rule 9A says summons given to the plaintiff for service. Now, this is a very important rule, Order 5 Rule 9A. It says that the court may, in addition to the service of summons under Rule 9, on the application of the plaintiff for the issue of a summons for the appearance of the defendant, permit such plaintiff to effect service of such summons on such defendant, and shall in such a case deliver the summons to such plaintiff for service. So, this is called personal service. I'm telling you that everyone, please keep your Bear Act with you and follow the video. Please keep your Bear Act with you, in front of you, open. Okay, now Rule 9A says the court may, in addition to the service of summons under Rule 9. So the general process will be always there. Now, in addition to that, the plaintiff, if the plaintiff applies for personal service, the court can also order the plaintiff to give direction to the plaintiff, or give summons and accompanied with the copy of the to the plaintiff to be delivered personally to the defendant. Okay. Now, the service of summons shall be effected to or on behalf of such plaintiff by delivering or tendering to the defendant personally a copy thereof signed by the judge or such officer of the court as he may appoint in this behalf. Now, if the plaintiff personally serves the summons or personally take up the duty of servicing the summons, now what will be the consequences? Now, the consequences will be the moment the plaintiff, the service of the summons shall be effected the moment to or on behalf of the plaintiff by delivering or tendering to the defendant personally a copy of the summons signed by the judge or such other officer, and sealed with the seal of the court or by some mode of service as is tendered in as is referred in subrule 3 of Rule 9. Okay. Now, subrule 3 says this is the exact provision which has been referred in the last line of the subrule 2. The provision of Rule 16 and Rule 18 shall apply to a summons personally served under this rule as if the person effecting the service were a serving officer. Okay. Now, if the person servicing the summon is doing it on a personal basis, now the provision of 18 and 19 which says about when it will be considered as duly served, these provisions will be applied to that personal service also. Now, subrule 4 of Rule 9 says if such summon when tendered is refused, or if the person served refused to sign an acknowledgement of service, or for any reason such summons is not served personally, the court shall, on application of the party, reissue such summons to be served by the court in the same manner as a summons to a defendant. So, if such summon when tendered is refused, or if the person served refuses to sign an acknowledgement of the service, he takes the summon but he refuses to sign an acknowledgement of receiving, or for any reason such summon is not served personally, the court shall, on the application of the party, reissue such summons to be served by the court in the manner as summons to a defendant. That is the general mode of service. Now, what is mode of service? 10 says mode of service of the summons shall be made by delivering or tendering a copy thereof signed by the judge or such other officer as he appoints in this behalf, and sealed with the seal of the court. Either delivering or handing over the copy to the defendant, or producing before him for the purpose of his receiving and telling him about the what it is all about, what is it, the summon. If now you must remember that refusal is a good service, refusal is a deemed service and a good service. If someone is refusing to receive the summons, that means he knows about the content of the summons. That's why he is trying to avoid the summon through which he thinks he may buy for some time for him, or trying to malafidely trying to delay the process of administration of justice. Now in such a case, that's why the refusal of summon, I mean express refusal of summon is what is a good service. Now rule 11 says service on several defendants. Save as otherwise prescribed, where there are more defendants than one, service of summons shall be made on each of the defendant. Okay. Now rule 12 says which to be service to be on defendant on person when practicable or on his agent. Now this is says rule 12 says whenever it is practicable, service shall be made on the defendant in person unless he has an agent empowered to accept service. In such case, service on such agent shall be sufficient. Okay. Now the general rule is that the summons must be served to the defendant personally unless he has an agent to who is specifically empowered to receive such summons. Now in such a case, if the summon is served to the agent, it will be deemed to be a good service or sufficient service. Okay. Now 13 says service on agent by whom defendant carries on business. Now rule 13 subrule 1 says in a suit relating to any business or work against a person who does not reside within the local limits of the jurisdiction of the court from which the summon is issued, service on any manager or agent who at the time of service personally carries on business or works for such a person within such limits shall be deemed to be a good service. And 2, for the purpose of this rule, the master of a ship shall be deemed to be the agent of the owner or charter. Okay. So in case of business, the manager or the agent shall be a servicing the summons to the manager or the agent who is carries on business or personally carries on such business or work for such person within such limits. Now the service of summons to that agent is a sufficient service. And in case of ships, the master of the ship or the captain of the ship will be deemed or shall be deemed to be the agent of the owner or the charter. Now rule 14 says service on agent in charge in suit for immovable property. Now service on agent in charge in suit for immovable property, this is a specific provision that is order 5 rule 14, where in a suit to obtain relief respecting or compensation for wrong done to immovable property, service cannot be made on the defendant in person and the defendant has no agent empowered to accept the service, it may be made on any agent of the defendant in charge of the property. Okay. If the personal service on the defendant cannot be is not practicable and defendant has not appointed any specific person for these specific purposes, then the property regarding which the litigation is going on at the time of institution of the suit, who is in charge of the property, that person will be deemed in the eye of law an agent of the original defendant. Okay. And service of summons to him will be a sufficient service. Now rule 15 says where service may be on an adult member of defendant's family. Now where in a suit the defendant is absent from his residence at the time when the service of summons is sought to be effected at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and he has no agent empowered to accept service of the summons on his behalf, service may be made on any adult member of the family, whether male or female, who is residing with him. So if the descendant is not present as his absent from his residence, and there is no possibility of reaching the defendant or finding the defendant within a reasonable time, then the service of the summons can be effected on any adult member, whether male or female, of that family who is residing with him. Now there is an explanation which is very important, that is a servant is not a member of the family within the meaning of this rule. Okay, now the adult male or female member must be a member of his family, and the servant, the person who is a servant of of his master, is not a member of the family. That has been clarified under this explanation. Now rule 16 says person served to sign acknowledgement. Person served to sign acknowledgement. Now, where the serving officer delivers or tenders a copy of the summons to the defendant personally or to an agent or to other person on his behalf, he shall require the signature of the person to whom the copy is so delivered or tendered to an acknowledgement of service endorsed on the original summons. So, when the process of delivering or tendering is completed, now the serving officer, it is the requirement of the serving officer or the duty of the serving officer to have an acknowledgement signed by the person who has been served with the summons. Okay. Now 17, procedure when defendant refuse to accept service or cannot be found. Okay, now this is what I am talking about just a few minutes ago, that where the defendant or his agent or such other person, as aforesaid, refuse to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and there is no agent empowered to accept service of the summons on his behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carries on business or personally works for gain, and shall then return the original to the court from which it was issued with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy and the circumstances under which he did so, and the name and the address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. So, procedure when defendant refused to accept service or cannot be found. Now in these cases, now the serving officer, what can the servicing officer do? The serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carries on business or personally works for gain, and shall then return the original to the to court from which it was issued. Obviously, if the defendant is refused or cannot be found, then the original is not acknowledged by the defendant. He will not have signed that original acknowledgement. So, the original as it is will be returned to the court from which it has been issued with a report. What report? With a report of the circumstances. The circumstances under which he did so, or he did do and the name and the address. If any person identified the house of the defendant, then the name of the person, and when he is doing his work, or when he is affixing the summon to a conspicuous part of the defendant's house, if anyone is present, then he must be named in the report. Okay, now 18 says endorsement of time and manner of service. Now the serving officer shall, in all cases in which summons has been served under Rule 16. What is Rule 16? We have just read. Rule 16 is person served to sign acknowledgement. Okay, person served to sign acknowledgement. This is the rule. And 18 says serving officer shall, in all cases in which the summon has been served under Rule 16, endorse or annex or cause to be endorsed or annexed on or to the original summons a return stating that the time when and the manner in which summons was served, and the name and address of the person, if any, identifying the person served, and witnessing the delivery or tender of the summons. So this is a report, another report of servicing of the summons. 17 says about the affixing the copy of the summon to a conspicuous part, and that report. Now 18 says about the the delivery and the all the general processes, and regarding that report. Now, what will now the servicing officer files the copy of the summon with acknowledgement, without acknowledgement, but with a report. Now, what is the purpose of filing this report? Now, examination of the serving officer. Now, where a summon is returned under Rule 17, we have just read that the defendant cannot be found who have not appointed any agent, and the circumstances are such that he cannot be found within a reasonable time. In such cases, where a summon is returned under Rule 17, the court shall, if the return under the rule has not been verified by the affidavit of the serving officer, and may, if it has been so verified, examine the serving officer on oath or cause him to be examined by another court touching his proceedings, and may take such further inquiry into the matter as it thinks fit, and shall either declare that summons has been duly served or order such service as it thinks fit. So, where the summon has not been personally, the serving officer is not able to personally serve the summons, and all the under all the other circumstances mentioned in Rule 17, he opted for the opted for affixing the copy of the summon to a conspicuous part of the defendant's house, or place where he personally resides or carries on business. Now, in that case, the report, if the report is verified with an affidavit or not, in both the cases, the court may, the court, if the report is not verified with an affidavit, the court shall, okay, in this case the court shall, but if the report is verified with an affidavit, the court may, if it has been so verified, examine the serving officer on oath, or direct another court to examine him touching his proceedings or under the circumstances under which he opted for such an such a option of servicing the summons. And if the court thinks that the serving officer has diligently performed his duty and waited for a reasonable time, and everything that can be done by a reasonable serving officer for the service of the summon has been done by that serving officer, then the court may, if the court thinks fit under the circumstances of the entire case, may declare that the summons has been duly served, or make order the again the service of the summons. Okay, that is the practical procedure. Now, this is Rule 19. Now, coming to Rule 19A, this is Rule 19 says extremely okay. Rule 19A says simultaneous issue of summons for service by post in addition to personal service. Okay. Now, the court shall, in addition to and simultaneously with the issue of the summons for service in the manner provided in Rule 9 to 18, both inclusive. Now, Rule 9, that is, I have told you that is a very specific rule, an important rule, where the plaintiff applies the court for personal service, or and now in such a case, the language was in addition to the, or the normal general procedure, the court can allow the plaintiff to serve the summons generally. Okay, now referring to that, the court shall, in addition to and simultaneously with the issue of the summons for service in the manner provided in Rule 9 to 19, both inclusive, also direct the summons to be served by registered post, acknowledgement due, addressed to the defendant or his agent empowered to accept the service at the place where the defendant or his agent actually and voluntarily resides or carries on business or personally works for gain. Okay. Now, provided that nothing in subrule and in this subrule shall require the court to issue summons for service by registered post. Provided nothing in this subrule shall require the court to issue summons for service by registered post, where in the circumstances of the case the court considers it unnecessary. So, if the court thinks it is unnecessary, the in this subrule, nothing in this subrule shall require the court to issue summons for service by registered post. Okay. Now, Rule 2, Subrule 2 of 19 says, when an acknowledgement purporting to be signed by the defendant or his agent is received by the court, or the postal article containing the summons is received back by the court with an endorsement purporting to have been made by a postal employee to the effect that the defendant or his agent has refused to take delivery of the postal article containing the summons when tendered to him, the court issuing the summons shall declare the summons had been duly served on the defendant. This is this exact provision, that is Order 5, Rule 19, Sub-Rule 2, where it has been specifically declared that if the summons is refused by the defendant, the court shall declare that the summons had been duly served on the defendant, provided that where the summons was properly addressed, addressed, prepaid, and duly sent by registered post, acknowledgement due, the declaration referred to in the subrule shall be made, notwithstanding the fact that the acknowledgement having lost or mislaid or for other reason has been received by the court within 30 days from the date of issue of the summons. Okay, now the proviso says that where the summons was properly addressed, prepaid, and duly sent by registered post, acknowledgement due, the declaration referred to in this subrule, that means the declaration by the postal employee to the effect that the defendant or his agent has refused to take delivery of the postal article containing the summons. This is the declaration we are talking about. Okay, the declaration referred to in this subrule shall be made notwithstanding the fact that the acknowledgement having lost or mislaid or for other reason has been received by the court within 30 days from the date of the issue of the summons. Okay, now this is coming to rule 20, very important rule of order 5, rule 20. This is called substituted service. We are talking about, first there is a general service, then rule 9 says about the personal service by the plaintiff, then coming to the serving officer taking a course under rule 17, that is affixing the copy of the summons to the conspicuous part of the house where the defendant resides. Now coming to the substituted service, where the court is satisfied that there is reason to believe that the defendant is keeping out of the way for the purpose of avoiding service, or that for any other reason the summons cannot be served in ordinary way, the court shall order the summons to be served by affixing a copy thereof in some conspicuous place in the courthouse, and also upon some conspicuous part of the house, if any, in which the defendant is known to have last resided or carries on business or personally work for gain, in such other manner as the court thinks fit. So where defendant is intentionally avoiding the service of the summons, defendant's house is very hard to identify which one is his original house where he resides. Now in such a case, and there is many other reasons for which the service of the summons cannot be affected. Now in such a case, if the court is satisfied, the court shall order summons to be served by affixing a copy thereof in some conspicuous place in the courthouse. Remember that in case of substituted service, the affixing the copy of the summon is first of all it will be affixed in a conspicuous place of the courthouse, and also upon the conspicuous part of the house, if any. That means if any house is found or found to be the house of the defendant, or if any in which the defendant is known to have last resided or carries on business or personally work for gain. It may not be his personal house, but in which he has known to have been have last resided or carries on business or personally work for gain in such other manner as it thinks fit. Now this is called substituted service. Now, the second rule, that is rule 1a, says where the court acting under subrule 1 orders service by an advertisement in a newspaper. The newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known to have actually and voluntarily resided or carries on business or personally works for gain. So in case of substituted service, whether without or in addition to the affixing of the copies, the court acting under subrule 1 orders service by an advertisement in the newspaper. Okay, now in such a case, the newspaper, what will be the criteria of choosing that newspaper? The newspaper must be circulating in the locality in which the defendant is last known to have actually and voluntarily resided, carries on business or personally work for gain. Now effect of substituted service, or order 5 rule 20 subrule 2. Please keep your barrack with you. Okay, effect of substituted service substituted by order of the court shall be as effectual as if it had been made on the defendant personally. Okay, so substituted service is also a good service. Now subrule 3 says where service substituted, time for appearance to be fixed. Where service is substituted by order of the court shall fix such time for the appearance of the defendant as the case may require. Okay, now in case of substituted service, the court will fix the date at which on which the defendant have to appear. Now, this is the provision of substituted service. Remember that Order 5, Rule 20 deals with the substituted service and the circumstances and the scenario we have just discussed about. Okay, now Rule 21, service of summons where defendant resides within the jurisdiction of another court. These are the very short provisions, very few short provisions which you have to remember for the purpose of your preliminary examination. That so Order 5, Rule 21 says service of summons where defendant resides within jurisdiction of another court. What will be the procedure? Summon may be sent to the court by which it is issued, whether within or without the state, either by one of its officers or by post to any court, not being the High Court, having jurisdiction in the place where the defendant resides. So, if the defendant is a resident within the jurisdiction of another court, the summons will be sent from the court where the suit has been instituted to the court where the defendant resides, or within whose jurisdiction the defendant resides, and that court will take the before mentioned procedure or resort to the before mentioned procedure from Rule 1 to Rule 20 for the purpose of serving the summon to the defendant. Okay, now 22 says service within the presidency towns of summons issued by courts outside. Now, if a court from outside wants to serve the summon to the to a defendant who is a resident within the jurisdiction of the presidency courts, what will be the procedure? Now, where a summon is issued by a court established beyond the limits of the town of Calcutta, Madras, Bombay, and is to be served within any such limits within the presidency towns, it shall be sent to the court of small causes within whose jurisdiction it is to be served. Okay, now the courts from outside will send to the court of small causes for the purpose of serving of the summons. Okay, now 23 says duty of court to which summon is sent. Now we have read about the 21 says where the defendant resides within jurisdiction of another court, and 22 says presidency service within presidency towns of summons issued by court outside. Now in both the cases the duty of the court to which summon is sent, I mean that means the court who is conferred with the duty, who is conferred with the duty of actually serving the summons to the defendant, what will that court do? That is, Order 23 says, the court to which a summon is sent under Rule 21 or Rule 22 shall, upon receipt thereof, proceed as if it had been issued by any such court, and shall then return the summon to the court of issue, together with the record, if any, of its proceeding with regard thereto. Okay, now upon receipt thereof, the proceed as if it had been issued by such court. That is the process of from Rule 1 to Rule 20. The court will resort to that provisions and the procedure, and after complying with that procedure or provisions, the court shall then return the summon to the court of issue, together with the record, if any, of its proceeding with regard thereto. Now, this the record of the proceeding will be whether it has been duly served with whether personal service by the plaintiff have been applied for or not, or whether substituted service have been effected. These are the record proceedings that will be taken by the court, and a report, that is the copy of the record, will be sent to the issuing court. Okay. Now, coming to 24, service on defendant in prison. Now, if the defendant is a prisoner, what will be the process? The defendant is where the defendant is sorry, where the defendant is confined in a prison, the summons shall be delivered or sent by post or otherwise to the officer in charge of the prison for the service on which for the service of the defendant. So, if the defendant is in prison, Order 5, Rule 24 says the summons shall be served to whom? The delivered or sent by post or otherwise the officer in charge of the prison is the person who will then serve the summon to the prisoner. Okay. Now 25 says service where defendant resides out of India and has no agent. So if the defendant is a resident outside India and has no recognized agent within the limits of the territory of India, now in such a case what will be the process? Now in such a case where the defendant resides out of India and has no agent in India empowered to act to accept service, the summons shall be addressed to the defendant at the place where he is residing and sent to him by post if there is postal communication between such place and the place where the court is situated. Okay, if there is postal communication, then the service of the summons will be effected through post, provided that where any such defendant reside in Bangladesh or Pakistan, the summons, together with a copy thereof, may be sent to the for service on the defendant to any court in that country, not being the High Court having jurisdiction in the place where the defendant resides. As simple as that. Provided further that where any such defendant is a public officer in Bangladesh or Pakistan, not being not belonging to the Bangladesh, or as the case may be Pakistan military, naval or air forces, or is a servant of railway company or local authority in that country, the summons together with a copy thereof may be sent to this sent for service on the defendant to such officer or authority in that country as the central government may by notification in the official gazette specify in this behalf. So in such cases where the defendant is a government officer in Pakistan or Bangladesh, or is a member of the military, naval or air forces, or servant in a railway company, in such cases the summons will be served or summons will be sent to a specific person for the purpose of serving the summons to the defendant and that specific person, who is the specific person, that specific person will be notified or authority in that country as the central government may by notification in the official gazette specify in this behalf. So that person will be the specific person. Okay, now 26, service in foreign territory through political agent or court. Now if the defendant is a resident of a foreign territory, now where in the exercise of any foreign jurisdiction vested in central government, a political agent has been appointed or a court has been established or continued with power to service a summons issued by a court and this court in any foreign territory in which the defendant actually and voluntarily resides, carries on business or personally works for gain, or the central government has by notification in the official gazette declared in respect of any court situated in any such territory or not established or continued in the exercise of any such jurisdiction as aforesaid, that service by such court of any summons issued by a court under this code shall be deemed to be service. Okay, so that specific office or that means the embassy in a foreign country of Indian embassy will serve the summons. Okay, now the summons may be sent to such political agent or court by post otherwise, or if so directed by the central government through a ministry of that government dealing with the foreign affairs, or in such other manner as may be specified in the central government for the purpose being served upon the defendant. And if political agent or court returns the summons with an endorsement purporting to have been made by such political agent or by the judge or other officer of the court to the effect that the summons has been served on the defendant in the manner herein before directed, such endorsement shall be deemed to be service of the summons. So if in case of foreign territory, the political agent or court which has been declared by the central government, our central government, to be a proper authority to serve the summons on the person who is a foreign resident, then that political agent or that concerned ministry or that specific court will run the process of serving the summons and return the issuing court the report of due service. Okay. Now 26A says summons to be sent to officer to foreign countries. Okay. Now these are not very important. You can read these provisions. Now we are just dealing about the important provisions. Okay. Now coming to 27, service on civil public or on servant of railway officer or on servant of railway company local authority, where the defendant is a public officer not belonging to the Indian military, naval or air force, or is the servant of a railway company or local authority. The court may, if it appears to it that summons may be most conveniently be so served, send it for service on the defendant to the head of the office in which he is employed, together with a copy to be retained by the defendant. Okay, together with a copy to be written, the head of the office will be served for the purpose of serving the summons on the defendant. Okay, now these 27 talks about service on civil public or on servant of railway officer or on servant of railway company or local authority. Now in these cases, the head of the office will be the proper authority to serve the summons. Now 28, service on soldier. This is very important to remember that Order 5 Rule 28 says or deals with the service of summons on whom? Soldiers, sailors and airmen. Where the defendant is a soldier, sailor or airman, the court shall send the summon for the service to his commanding officer together with a copy to be retained by the defendant. Okay. Now in previous case, to whom? In case of head of the office in which he is employed, in 27, and in case of 28, the commanding officer together with a copy to be written by the defendant. 29, duty of person to whom summon is served or sent for service. Now in such cases where 24, 27 and 28 we have just read, in these cases what will be the duty of the person who have been to whom the summons is sent for the purpose of serving the summons to the defendant? Where a summon is delivered or sent to any person for service under 24 and 27, 28, such person shall be bound to serve it if possible and to return it under his signature with the written acknowledgement of the defendant, and such signature shall be deemed to be evidence of service. Okay, now that person will, it is the duty of that person to serve the summon on the defendant and sign an acknowledgement from, take an acknowledgement from the defendant and returning the summon with the signature of himself that the summon have been duly served. Now, where from any cause service is impossible, the summons shall be returned to the court with a full statement of such cause and of the steps taken to procure service, and such statement shall be deemed to be evidence of non-service. Now, where he fails, or that specific person or the political agent or whatever it is, that is 24, 27 and 28, the person specified in those rules, this person fails to serve the summon. In such a case, he will, in such a case, what will he do? Where from any cause service is impossible, the summon shall be returned to the court with a full statement to that effect or of such cause or the steps he has taken to serve the summons, and such statement shall be deemed to be evidence of non-service. Okay, now coming to rule 30, that is substitution of letter for summons. Now, where it is mandatory or necessary for the purpose of courtesy and the matter of prudence that the summons, the word letter is substituted in the place of summons. What is the scenario? The court may, notwithstanding anything herein before contained, substitute for a summon a letter signed by the judge or such officer as he may appoint in this behalf, where the defendant is, in the opinion of the court, of a rank entitling him to such mark of consideration. Okay, if the person to be served with the summons is a person of a high rank and the court thinks it is as a matter of respect, then the process is will be of a delivery of a letter. Okay, not of service of summons. Okay, a letter substituted under sub rule 1 shall contain all particulars required to be stated in a summon, and subject to the provision of rule 3 shall be treated in all respect as a summon. So the letter will be treated as a summon, but it will be called as a letter just because the person to whom the letter or summon is served is a person of a high rank. It is a showing of a respect to that rank. Okay. Now 3, a letter so substituted may be sent to the defendant by post or by a special messenger selected by the court or in any other manner which the court thinks fit, and where the defendant has an agent empowered to accept service, the letter may be delivered or sent to such agent. Okay, now in case of letters or the servicing the summon or letter to a person of high rank, the court may send it through post or by a special messenger selected by the court, or in any other manner in which the court thinks fit, and where there is a specific person appointed by that person of high ranking to deal with this receiving of summons, now the letter will be delivered to his office. Okay, so this is order 5. Order 5, that is service of summons.